morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare a recess at any time. I'd like to begin today by recognizing that this markup is occurring at the same time as the joint subcommittee hearing with the Committee on Oversight and Government Reform and our subcommittee on the Constitution and Civil Justice next door. Obviously, this is not an ideal situation, and we generally try to avoid scheduling conflicts. However, this week is a particularly difficult one with the joint session of Congress tomorrow and various other competing priorities. I certainly do not intend for this to be a precedent. However, I would like to ask for the cooperation of all members in helping us finish this bipartisan markup quickly so that members who choose to do so may attend the hearing next door. Pursuant to notice, the business before the committee today is a resolution to establish the House Committee on the Judiciary Oversight Criminalization Task Force, and the clerk will report the resolution.
Resolution establishing the House Committee on the Judiciary Over-Criminalization Task Force of 2013.
Without objection, the resolution is considered as read, and I will begin by recognizing myself and the ranking member of the Crime Subcommittee for opening statements. At present, there are an estimated 4,500 federal crimes in the United States Code, many of which address conduct also regulated by the states. According to a study by the Federalist Society, the number of federal criminal offenses increased by 30% between 1980 and 2004. There were 452 new federal criminal offenses enacted between 2000 and 2007, averaging 56.5 new crimes per year. Over the past 3 decades, Congress has been averaging 500 new crimes per decade. The expansion of the federal code has brought with it an ever-increasing labyrinth of federal regulations, often which impose criminal penalties without requiring that criminal intent be shown to establish guilt. One such example includes an 11-year-old girl who saved a baby woodpecker from the family cat and decided to keep her inside a small cage for a couple of days to make sure the bird wasn't injured. While there was no evidence that this 11-year-old girl intended to break the law, she violated a federal statute against the possession or transport of a migratory bird and received a $535 fine. Today, the committee will adopt a resolution authorizing a task force on overcriminalization to conduct hearings and investigations and issue a report on overcriminalization in the federal code, as well as possible solutions. The task force will be authorized for 6 months and will be led by Crime, Terrorism, Homeland Security, and Investigations Subcommittee Chairman Jim Sensenbrenner and Ranking Member Bobby Scott. Members of the task force include Spencer Backus, Louis Gohmert, Raul Labrador, George Holding, Jerry Nadler, Steve Cohen, Karen Bass, and Hakeem Jeffries. Ranking Member Conyers and I will serve as ex officio members of the task force. As federal criminal laws and regulations have increased, so has the number of Americans who have found themselves breaking the law with no intention of doing so. Numerous examples, ranging from a man charged with trespassing a federally protected wilderness area while trying to dodge a blizzard on his snowmobile, to a dad and his son collecting arrowheads on federal land, show we need to take a closer look at the laws on the books to make sure Americans who make innocent mistakes are not charged with criminal offenses. I am hopeful that the bipartisan task force established today will be able to reach consensus and make recommendations to the House Judiciary Committee on how to improve our federal criminal statutes. I wish to thank Ranking Member Conyers, Crime Subcommittee Chairman Sensenbrenner, and Ranking Member Scott for joining me to create this bipartisan task force, and I urge my colleagues to join us in approving the resolution. It's now my pleasure to recognize the gentleman from Virginia, Mr. Scott, for his opening statement.
Thank you, Mr. Chairman. I'd first like to ask unanimous consent that a statement from the Ranking Member, Mr. Conyers, be entered into the record.
Without objection, it will be entered into the record with pleasure.
Thank you. And I want to thank you, Ranking Member Conyers, and Crime Subcommittee Chairman Mr. Sensenbrenner, for bringing forth this resolution for markup today. I'm pleased to join you and my colleagues in moving this matter forward and to see the high level of interest that has been expressed in making needed improvements in our federal criminal justice system. Look forward to all interested parties in bringing about those improvements. The U.S. Criminal Code has dramatically expanded in size and scope since it was last recodified about 50 years ago. Although crime is primarily a matter of state and local law, Over the last 40 years or so, Congress has increasingly sought to address societal problems by adding criminal provisions to the federal code. At present, there are approximately 4,500 federal criminal codes in the U.S. Code, and many are redundant, and many have not been enforced or utilized by prosecutors for many years. It's been estimated there may be as many as 300,000 or more federal regulations that can be enforced with criminal penalties. And far too many of these criminal offenses and regulations lack adequate criminal intent or mens rea requirement to protect the innocent. As a result, we're hearing many complaints of overuse and abusive uses of the Federal Criminal Code from a broad-based coalition of organizations, including the Heritage Foundation, the National Association of Criminal Defense Lawyers, the Cato Institute, the ACLU, and the Washington Legal Foundation. Historically, a mens rea requirement such as specific intent, willful intent, or knowledge of the specific facts constituting an offense was part of almost every common law crime. Increasingly, however, modern criminal law has forsaken the guilty mind requirement. This is an alarming trend because mens rea plays an important role in protecting the innocent and those who do not intend to commit wrongful or criminal acts from conviction and punishment. Yet, since 2000, figures show that Congress has created an average of more than 50 new criminal crimes every year. It's about one a week. And as a result of this continuing emphasis on criminalizing more and more activities, often with vague, missing, or non-existent criminal intent standards, the number of federal prisoners has risen from about 25,000 in 1980 to over 200,000 today. It is a big part of making the United States the world's largest incarcerator by far in terms of incarceration rate, about 7 times the international average. And the Pew Research Center has calculated that our incarceration rate is so high that it's actually adding to crime, not solving crime. And as a result, today we're establishing the Bipartisan Overcriminalization Task Force to assess issues and make recommendations for improvements to these problems. The work of the task force will involve identifying improvements to the federal criminal law that we can all agree on. For example, I think we all agree upon requiring that every crime have a specific criminal intent or mens rea requirement, and also believe that we can agree on steps of moving all federal crimes into Title 18 of the U.S. Code. The task presented by this resolution is an important undertaking, and doing it right and effectively will require a major commitment of time and attention and must involve participation and input not only from the members of both parties of the House and Senate, but also a diverse gathering of other interested parties, including organizations in the Overcriminalization Working Group I mentioned earlier. We'll also need the help of criminal law researchers, federal law enforcement community, representatives of the judiciary, including the U.S. Sentencing Commission and the administrative offices of the courts, and other interested organizations and professionals. I look forward to working with my colleagues and all interested parties in pursuing this important bipartisan effort. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Conyers, Mr. Scott. And now I would like to recognize the chairman of the Crime, Terrorism, Homeland Security, and Investigation Subcommittee and the proposed chairman of the Overcriminalization Task Force, the gentleman from Wisconsin, Mr. Sensenbrenner.
I thank the gentleman for recognizing me, and you know, usually when you're proposed as a chairman, a lot of these chairmanships around here don't entail very much work. This one will entail a lot of work, but I think it's necessary. The task force established by this resolution continues the committee's bipartisan review of overcriminalization and over-federalization begun 2 Congresses ago. The Crime Subcommittee held hearings in both the 111th and 112th Congress to resurrect important policy discussions that have been dormant for over 2 decades about the breadth and scope of federal criminal law. Today, there are roughly 4,500 federal crimes on the books, and still many more regulations and rules that not abided by result in criminal penalties, including incarceration. Many of these laws impose criminal penalties, often felonies, for violation of federal regulations. Americans are expected to know that it's wrong to commit murder or burglary or engage in an act of terrorism, regardless of what the law says. But today, Americans must contend with literally thousands of obscure and cumbersome federal regulations. A simple misreading or ignorance of a regulation can land a person in prison. An even more fundamental issue raised by such regulation is whether the prohibited conduct should be criminalized in the first place. Unfortunately, many regulatory crimes improperly define the elements of criminality, including omitting or improperly defining the appropriate level of criminal intent. The growth in criminal regulations has also caused an expansion of the number of federal agencies empowered to investigate this criminal, close quotes, conduct. We are all familiar with criminal investigation agencies like the FBI, DEA, or ICE, but how about the National Marine Fisheries Service within NOAA, or the Office of Criminal Investigations within the FDA? Along with broad sweeping criminal regulations comes a host of investigative agencies eager to enforce them. The goal of this task force is to conduct a more in-depth analysis of these and other over-criminalization and over-federalization issues, to identify improvements to federal law and the House rules, and to make bipartisan and hopefully unanimous recommendations to the committee. It's been over 50 years since the criminal code was last revised. The existing code is riddled with provisions that are either outdated or simply inconsistent with more recent modifications to reflect today's modern approach to criminal law. Through the years, the code has grown with more and more criminal provisions, some of which are antiquated or redundant, some of which are poorly drafted, some of which have not been used in the last 30 years, and some of which are unnecessary since the crime is already covered by existing criminal provisions. Today, I will reintroduce the Criminal Code Modernization and Simplification Reform and recodify Title 18 of the Code. This effort to reform the Federal Criminal Code has resulted in a bill that exceeds 1,200 pages in length, and this bill only encompasses Part 1 of Title 18. If nothing else, the sheer volume of this bill brings into specific focus the breadth of the Federal Criminal Code and the need for reform. I look forward to working with Ranking Member Scott and the other members of the task force to identify common sense and bipartisan solutions, not only to reform the criminal code within Title 18, but also the myriad of criminal laws that are scattered throughout many of the 59 titles of the code. And I thank the Ranking Member and Chairman for their support in the creation of this bipartisan task force. Yield back the balance of my time.
I thank the gentleman. Is there further discussion on the resolution?
Mr. Chairman.
The gentlewoman from Texas is recognized for 5 minutes.
Chairman, let me congratulate the proponents of this task force, having worked on the subcommittee on crime. I could list a whole litany of professions where in the work of their office and the paperwork that they have, physicians come to mind that innocent mistakes can wind up in criminalization. Although I know that this particular statute has not been cited, but I don't know how many Americans realize that 18 U.S.C. 1001 provides a vast breadth and depth of filings that may, through inadvertentness, wind up as a criminal offense and a felony. So I welcome and congratulate the effort. Hope that there will be an opportunity for members to sit in on some of the hearings that will be held. And I think this is a right and forward-thinking direction of this particular committee. With that, I yield back.
I thank the gentlewoman, and the gentleman from Texas, Mr. Gomer, is recognized for 5 minutes.
Thank you, and I too want to thank you, Chairman, and the Ranking Member, and Chairman Sensenbrenner, and Ranking Member Bobby Scott. This has, as Chairman Sensenbrenner pointed out, been an issue for 4 years, and I think former Attorney General Ed Meese is to be commended for his work and the efforts there at the Heritage Foundation, the others working with former Attorney General. And one of the things he suggested that I'm sure will be considered is, in order to discourage future proponents of legislation from inserting a prison sentence just to show how tough and macho the individual congressperson is, that they should have to come to judiciary on top of whatever other committee has jurisdiction, so that this body, this committee, can slow such efforts down, because it has, on both sides of the aisle, both parties have had people thinking they will show how tough they are on an issue by sticking a prison sentence in that. And so I hope that will be one of the things that we will consider in our efforts to rein this in, so that innocent people with no mens rea don't end up being guilty because of overzealousness of legislators. And I yield back. Thank you, Mr. Chairman.
Would the gentleman yield? I just want to assure the gentleman and all the members of the committee that the Judiciary Committee has jurisdiction over any legislation brought before the Congress that imposes criminal penalties, and we are carefully watching every bill that is introduced and referred to make sure that we have the opportunity to have input on anything related to the criminal code.
And I think the chairman, what was found in the last 4 years is that a lot of times it didn't come to judiciary, even though there was a prison sentence. It just went to the primary committee of jurisdiction, and there's also a reason why it didn't end up in 18 U.S.C. It would be somewhere else, which has made it so difficult to figure out just how many federal crimes there are.
Those points are very well taken.
But I'm proud to have a chairman that's going to zealously watch that, and I appreciate it.
Would the gentleman yield from Texas?
Sure.
A question to the chairman. Mr. Chairman, will regular order follow that members of the Judiciary Committee will have the opportunity to sit and listen to any hearings that this committee may hold?
Yeah, I think that would be an appropriate policy for this task force to have. Again, the task force members need to be able to do their work.
Right.
So it will just be the ability to sit in and observe and not participate in the task force. But we would welcome that observation.
Mr. Chairman,
Gentleman from
a
Virginia.
follow-up question to that. If someone is participating, a member of the Judiciary Committee, but is yielded time by a member of the task force, could they participate?
That's the approach that we have taken with regard to a subcommittee participation. So I would imagine that there would be no objection to proceeding the same way with the task force.
Thank you. Thank you. I yield back.
Are there other members who wish to be recognized? If not, a reporting quorum being present, the question is on adopting the resolution. Those in favor will say aye. 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 Those opposed, no. The ayes have it, and the resolution is adopted. Now, pursuant to notice, I call up H.R. 180 for purposes of markup, and the clerk will report the bill.
H.R. 180, to encourage, enhance, and interrogate Blue Alert plans through the United States in order to disseminate information when a law enforcement officer is severely injured or killed in the line of duty.
Without objection, the bill is considered as read and open for amendment at any point, and I will begin by recognizing myself for an opening statement. According to the National Law Enforcement Officers Memorial Fund, a law enforcement officer in the United States is killed in the line of duty every 57 hours, or one about every other day. This bill helps to reverse that trend when police officers and the public join forces to capture fleeing suspects. Our nation's law enforcement officers risk their lives every day. They often work long hours in stressful and dangerous conditions and run a high risk of being injured or killed. This bill encourages the expansion of an integrated Blue Alert communications network throughout the United States, which is similar to the well-known Amber Alert system used to locate missing and abducted children. A Blue Alert broadcasts information and speeds apprehension of violent criminals when a law enforcement officer is seriously injured or killed in the line of duty. Like Amber Alerts, Blue Alerts help hinder an offender's ability to escape and facilitate their capture. The Blue Alert system is a cooperative effort among local, state, and federal authorities, law enforcement agencies, and the general public. A Blue Alert provides a description of an offender who is still at large and may include a description of the offender's vehicle and license plate information. This bill directs the Department of Justice to designate an existing Department of Justice official as the Blue Alert National Coordinator, who will encourage those states which have not already done so to develop Blue Alert plans and establish voluntary guidelines. It will remain incumbent on each state to develop its own Blue Alert procedures. As of today, 15 states, including my home state of Virginia, have Blue Alert networks in place. Indiana and Connecticut will implement their networks later this year. An integrated nationwide Blue Alert system ensures that when tragedy strikes, the public is on notice and suspects can be more quickly apprehended and brought to justice. A nationwide Blue Alert network will be particularly effective when a suspect flees across state lines. This committee has a long history of passing legislation which enhances law enforcement's tools to fight crime, keeps Americans safe, and eliminates wasteful government spending. This bill achieves these goals by efficiently using existing DOJ resources to provide enhanced protections to our communities and our law enforcement officers. Too often, criminals in our society have no respect for authority and the rule of law. This bill reaffirms our determination to ensure the future safety of our law enforcement men and women and the communities they serve to protect every day. Supporters of this legislation include the National Fraternal Order of Police, the National Sheriff's Association, the Federal Law Enforcement Officers Association, the Sergeants Benevolent Association, and the National Association of Police Organizations. I want to thank Mr. Grimm of New York and Mr. Reichert of Washington for their work on this bipartisan, bicameral legislation, and I urge my colleagues to support it. Without objection, statements from Mr. Grimm and Mr. Reichert will be made a part of the record, and without objection, letters of support from the above-named organizations will also be made a part of the record. And the chair now recognizes the gentleman from Virginia, the ranking member of the Crime, Terrorism, Homeland Security, and Investigation Subcommittee, Mr. Scott, for his opening statement.
Thank you, Mr. Chairman. And again, I'd like to ask unanimous consent that a statement from the ranking member, Mr. Conyers, be made part of the record.
Without objection, it will be made a part of the record.
Mr. Chairman, I'm pleased that today we're considering this important bill that will make us safer from those who will attack, kill, or seriously injure police officers. H.R. 180 would establish a network of communications in the Department of Justice to issue blue alerts to help apprehend individuals suspected of committing these serious crimes, and would encourage states to establish blue alert notification systems. Over a dozen states, including our home state of Virginia, have blue alert systems in place to use media broadcasts and roadside message signs to disseminate within their respective borders information giving detailed descriptions about those who are suspected of these crimes. The type of information broadcast includes a description of a suspect's vehicle and license plate number. This bill will assist states in initiating and implementing these programs on a voluntary basis, and would establish the Department of Justice as the facilitator of sharing blue alert information among states, so that notification may be disseminated across state lines and throughout an entire geographical area, which may most reasonably be reached by the suspect. We need to encourage the dissemination of this information because of the seriousness of these crimes and the need to protect the public. I therefore urge approval of H.R. 180 by this committee and yield back the balance of my time.
I thank the gentleman. If there are other members who would like to make statements, they can seek recognition, and we'll also at the same time ask if there are any amendments to H.R. 180. If there are no amendments and no other requests to speak, we will call for a vote. A reporting quorum is present. The question is on reporting the bill favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporate. Oh, it's not applicable. Pursuant to notice, I now call up H.Res. 196 for purposes of markup, and the clerk will report the resolution.
H. H.Res. 196, supporting the Sixth Amendment to the United States Constitution, the right to counsel.
Without objection, the resolution is considered as read and open for amendment at any point, and I will begin by recognizing myself and the ranking member for opening statements. I support House Resolution 196, introduced by Representative Ted Deutsch of Florida, a resolution supporting the Sixth Amendment to the Constitution, the right to counsel, and strategies to improve the criminal justice system to ensure that indigent defendants in all felony cases are adequately represented by counsel. 50 years ago, the Supreme Court in Gideon v. Wainwright held that providing counsel to indigent defendants is one of the essential requirements of the Sixth Amendment of the United States Constitution. In the court's opinion, Justice Black stated, quote, "Reason and reflection require us to recognize that in our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This seems to us to be an obvious truth. Since the Gideon decision, the Supreme Court has held that absent a knowing and intelligent waiver, no person may be imprisoned for any offense, whether classified as petty, misdemeanor, or felony, unless he was represented by counsel at his trial. This resolution reaffirms Congress's continued commitment to pursuing fairness in our criminal justice system, and I urge members to support it. And I now recognize the gentleman from Virginia, the ranking member of the Crime Subcommittee, Mr. Scott.
Thank you, Mr. Chairman. I'd ask unanimous consent that a statement by the ranking member, Mr. Conyers, be made part of the record.
Without objection.
And, Mr. Chairman, 50 years ago, the Supreme Court ruled in Gideon v. Wainwright that defendant Clarence Earl Gideon should have had a lawyer. The court stated Mr. Gideon said that he wanted a lawyer, and the court said that it was a luxury, not a necessity. And the Supreme Court has ruled since then that, let's see, who is it? Justice Black stated, "From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to ensure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with a crime has to face his accusers without a lawyer to assist him." Mr. Chairman, I ask unanimous consent that a recent news article outlining the challenges faced by public defenders, especially under the sequester, be entered into the record.
Without objection, so ordered.
And I yield the balance of my time to the chief sponsor of the legislation, the gentleman from Florida, Mr. Deutsch.
I thank the gentleman. H.Res. 196 is a bipartisan resolution that the House of Representatives supports the Sixth Amendment to the U.S. Constitution, the right to counsel. In addition, the resolution provides that the House of Representatives supports strategies to improve the criminal justice system to ensure that indigent defendants, people who cannot afford an attorney, are adequately represented by counsel in all felony cases. 50 years ago, the Supreme Court recognized in the landmark case of Gideon v. Wainwright that counsel must be provided to indigent defendants in all felony cases. The unanimous opinion of the court held that providing counsel to indigent defendants in all felony cases meets the essential requirements of the Sixth Amendment. In Argersinger v. Hamlin, the Supreme Court further held that the Sixth Amendment right to counsel entitles an indigent person to be represented by counsel in all cases where imprisonment is a possibility. 50 years later, our nation continues to struggle to ensure that indigent criminal defendants have access to quality representation of the courtroom. Representation for the indigent has been undermined by crushing caseloads that make it nearly impossible for lawyers to provide quality counsel for each trial. In these difficult economic times, states have also been forced to slash their budgets, causing funding for indigent defense to be substantially cut or eliminated. In addition, counsel representing indigent defendants have been unable to access investigators or experts that are essential to provide adequate defense. The Supreme Court recognized in Gideon that the right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. And yet in many parts of the country, the fundamental right of an indigent person to be represented by counsel is not being respected. Justice Sotomayor pointed out in a lengthy dissent and dismissal of writ in Boyer v. Louisiana that the Louisiana Supreme Court has suggested that a failure to provide funding to the state's indigent defense system is contributing to extended pretrial detentions. This morning, the judiciary will, I hope, through this bill, make clear that we support strategies to ensure that the right to counsel that Gideon trumpets is protected. I'd like to thank Chairman Goodlatte for bringing up this resolution in committee and for his support of the Sixth Amendment. I'd also like to thank Congressman Shabbat for all of his hard work on this resolution and for working to ensure that indigent people in the criminal justice system are represented by counsel. Finally, I'd like to thank Ranking Member Conyers and Crime Subcommittee Ranking Member Scott for their support of strategies to improve indigent defense systems. I urge support for H.Res 196, and I yield back the balance of my time.
I thank the gentleman for his remarks and for bringing forward this resolution. And for what purpose does the gentleman from South Carolina seek recognition?
Move to strike the last word and seek 5 minutes.
The gentleman's recognized for 5 minutes.
Mr. Chairman, I don't mean to be any more difficult than I normally am, and of course I support the Sixth Amendment, which incidentally enough stands for a whole lot of propositions, not just the right to counsel. If this resolution were simply to affirm what we all believe, which is that you have a right to counsel not only in felony cases now, but also misdemeanor cases, I wouldn't have sought time, but it seems from some of the comments made on the other side of the aisle that this has become an indictment on sequestration, and that we want to talk about federal public offenders being cut, when the reality is the FBI has been cut, the United States Attorney's Office has been cut, state DA's offices are furloughing employees. So my question is this, specifically with respect to prong number 2, support strategies to improve the criminal justice system. Who in the world could possibly be opposed to that, but not wanting to be successful there and stop, to ensure the indigent defendants in all felony cases are adequately represented by counsel? I'm not aware of any cases where they're not. I think there have been 3 attorneys that have been appointed for the bomber in Boston, Mr. Chairman, if I'm not mistaken. So if this is about sequestration and just another effort to highlight that, there are plenty of prosecutors that are being cut, plenty of law enforcement. If this is to affirm your right to counsel, count me in. If it's more than that, which is what it sounds like to me, we got a bunch of amendments. I mean, let's affirm the 8th. Let's affirm the 4th. So I guess my question is, why the 6th, and why do we have to inject politics into something where we're supposed to be memorializing and commemorating and celebrating an amendment to the Constitution?
Will the gentleman yield?
Certainly.
I think the purpose of this resolution is to celebrate the 50th anniversary. It is not unusual to celebrate anniversaries of important measures, and the Gideon decision, I think, was a landmark decision, and that's why it's being done today.
Well, the gentleman from Virginia knows that there's not a member of this body that I have more respect for than him, and if he tells me that, then I'm inclined to believe it. But I can also say that I just heard talk about sequestration and cutting budgets, and that's not Gideon versus Wainwright, and cops and prosecutors and everyone else have been cut too. So I take the gentleman from Virginia at his word. There's no one in this body whose opinion I respect more, and if he says it's to celebrate Gideon versus Wainwright, I believe him. But I heard more than that from the other side of the dais just a few minutes ago, and with that, Mr. Chairman, I'll be happy to yield back.
Well, the gentleman's observations are pertinent, and I would just say to the gentleman that we have carefully examined the language of this to make absolutely sure that it does, just as the gentleman from Virginia suggested, celebrates the Sixth Amendment right to counsel as recognized in the case of Gideon versus Wainwright, and not to get into issues of how that is fulfilled by the federal government and by state governments. And the gentleman from Texas is recognized.
I want to thank you, Mr. Chairman. I want to congratulate the sponsor of the bill, gentleman from Florida, and also our fellow Judiciary Committee member, Mr. Chabot, who I know has read the bill 2 pages and sees the 4 corners of the bill is not only the acknowledgement of Gideon versus Wainwright, which I think is a very important interpretation of this, of the Sixth Amendment, and I think I would like to focus on the importance of the indigent having effective counsel, which is what has generated out of that decision, and that's an important statement because it equalizes the criminal justice system, and it suggests that no matter what your economic condition, under our Constitution, you are not diminished from the rights of a fair trial and a effective counsel. I'd like to offer into the record just information about an individual by the name of Willie Genome Manning, who is scheduled today for execution, and a simple request was made for DNA testing. We don't know what the ultimate results will be of his fate, but I can assure this body that the re-emphasis on the Sixth Amendment ties into ensuring that fairness goes to all, from those who have perpetrated non-heinous crimes to those who have perpetrated heinous crimes, and it is not a judgment of their fiscal or their financial ability to be able to, if you will, have effective counsel. So I want to support this legislation on the grounds of so many constituents that I have seen in my jurisdiction who have suffered incarceration primarily because they've not had counsel, effective counsel. And I think the Sixth Amendment emphasizes that. And finally, I'd like to congratulate the resolution because it adds to have us support strategies to improve the criminal justice system to ensure that indigent defendants in all felony cases are adequately represented by counsel. I think this is commendable and certainly worthy of the Judiciary Committee's work, and I support and ask our colleagues to support it. With that, I yield back.
I thank the gentlewoman. What purpose does the gentleman from Pennsylvania seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
If my good friend from Florida, his intent behind this resolution is to commemorate one of the cornerstones of the jurisprudence system, I support him wholeheartedly. If this is a death penalty argument, then we have a different issue here. And we're going off into an area where I think is getting very, very far from what my friend from Florida intended. And if you would respond to that.
I would be happy to. I can't. We can have a debate on this dais about the death penalty and any other topic. The resolution that we're discussing now, the resolution that I've introduced, is one that commemorates the 50th anniversary of Gideon. That's what it does. It's very clear about that, and the chairman has been very kind to work with us to ensure that it does no more than that.
And I just needed reinforcement from my friend from Florida, but let me make this point perfectly clear. I've prosecuted thousands of cases from the state level to the federal level, and particularly at the federal level, before an attorney can be hired, a defense attorney can be hired, a federal public defender, the judges, the federal court has to approve that and has to approve that those individuals, he or she, is competent. And I've had many situations where it's been raised that the expense of an investigation on the defense side, where the courts have ruled rightly so, expense has nothing to do with it. We have to supply and offer and make certain that defendants who are charged have adequate counsel, regardless of what the cost is, regardless of how many investigators are required and needed. So with that, I want to just
Would the gentleman yield?
Certainly.
I thank the gentleman, and I appreciate the gentleman's both service and and I do want to reaffirm that the gentleman from Florida's resolution stands on its own. All I see in that is the affirmation of Gordon, of the Wainwright case. But I do want to emphasize and join with the gentleman from Pennsylvania that he is right. And I think the Supreme Court case upon which we are honoring in this resolution has laid the groundwork for such to happen during the tenure of my practice, during the tenure of the gentleman's practice, is that we do work to ensure that those without means have effective counsel. And I think that this lawsuit, Supreme Court case, and now the acknowledgement of it is worthy of the Judiciary Committee because it has made changes such as those that you have just enunciated in your practice. With that, I'll yield back.
Okay, thank you. And in closing, I've had situations where defendants have just simply argued with the court saying, I'll represent myself. And as a prosecutor at both levels, we've insisted with the court, and they follow through with it, that even though a defendant wants to go pro se, there is backup counsel there sitting right with that individual to make sure that he is not or she is not making mistakes that could jeopardize their case. With that, I yield back.
I thought the gentleman yield.
Yes.
I thank the gentleman for yielding. I just want to assure the gentleman that the intention of this resolution is to honor the good work that you and Congressman Gowdy and others who have been so involved in the criminal justice system have the diligent effort that's been made to honor that principle in the Sixth Amendment and not to cast aspersions upon it. Obviously, as we can see here today, there are differences of opinion about what needs to be done to assure that, but this is only about celebrating the fact that we do assure that, and you and others have played a role in doing that, and we thank you for that.
Mr. Chairman.
Who seeks recognition? The gentleman from Ohio. For what purpose do you seek recognition?
Move to strike last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I won't take the 5 minutes. I just wanted to make very clear that if this resolution in any way reflected opposition to the death penalty, my name wouldn't be on it. I think Mr. Scott knows that. And I was a defense attorney for quite a few years prior to this, had capital case and other things as well. I think we worked in good faith with the folks on the other side of the aisle on this issue, and it was just to celebrate the 50th anniversary of Gideon versus Wainwright, which was critical in criminal law history, and so that's what it's about. And members are free to take their time to talk about various issues, and I don't think we have any problem with that, but I just want to make sure that this doesn't in any way reflect opposition to the death penalty, nor does it represent on the other side of the aisle folks in favor of the death penalty either. So I yield back.
I thank the gentleman for his comments, and I subscribe to them. Are there further requests for recognition? Are there any amendments? For what purpose does the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
I would just add that the right to counsel entails the right to effective counsel, and effective counsel means quite a bit here, and I think we should all keep that in mind as well. With that, I will yield back.
I thank the gentleman for his comments. Are there any further requests for recognition? Are there any amendments? If not, a reporting quorum being present, the question is on reporting the resolution favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the resolution is ordered reported favorably. Members will have 2 days to submit views.
Mr. Chairman.
For what purpose does the gentleman from Texas seek recognition?
I ask unanimous consent to speak out of order for 1 minute, please.
Without objection, the gentlewoman is recognized for 1 minute.
Thank you, Mr. Chairman. I did not want to speak on the time frame of the gentleman from Florida's bill, because I'm the one that raised the question of the death penalty, and I want to clarify the record that I hope that we will have a discussion about the death penalty. Maybe we'll have a hearing on it. But the point that I wanted to make is the point on effective counsel. The individual in Mississippi has been denied the use of DNA evidence. And so that had to tie into counsel, which I think all of us have a unified view of, and I imagine the gentleman was indigent. And so maybe someday in this particular Judiciary Committee, Mr. Chairman, we'll have that vigorous debate and discussion about the death penalty. Some of us would argue the point that you're not against the death penalty. Some will argue that they are for it. But all of us can say that you want the person that happens to get the sentence to, in fact, actually be guilty beyond a reasonable doubt. That was the point that I was making as it relates to effective counsel, and I'm delighted that the gentleman's resolution has passed, and I thank the chairman for allowing me to clarify my comments not to infringe upon the gentleman's resolution. With that, I yield back.
I thank the gentlewoman for her comments. This concludes our business for today. Thanks to all of you for attending. The meeting is adjourned.